and welcome to the 14th meeting this year of the Committee on the Scottish Government Handling of Harassment Complaints. Our first agenda item was to consider whether to take evidence in private from the Lord Advocate before we hear from him in public. This committee has always sought to carry out its work in a way that is open and transparent, and this is not always easy, given the legal constraints upon us, especially in relation to Lady Doreen's order protecting the anonymity of complainers. I am grateful to the Lord Advocate for his offer of evidence in private, which I believe would have allowed the committee to understand in more detail the background to the publication and redaction of the former First Minister's submission on the Ministerial Code. However, despite the majority of the committee wishing to proceed in that way, in the absence of unanimity from the committee, I have agreed with the Lord Advocate that we should move straight to evidence in public. I understand that the Deputy Convener wishes to say something at this point. Margaret Mitchell.
Thank you, Convener. Can I say at the outset that I welcome the Lord Advocate's decision that today's evidence session, where he's giving evidence as the Scottish Government's chief legal advisor, will be held fully in public. However, before doing so, he must first fulfil his duty as head of Scotland's Independent Prosecution Service and give his view of whether it was justified for the Crown Office to send the letter to the Scottish Parliamentary Corporate Body in relation to the evidence from Alex Salmon published by the Parliament. Last week, the Lord Advocate confirmed to Parliament that in that role as head of the Prosecution Service, all decisions taken by him and by the Crown and Procurator Fiscal Service are taken in the public interest. As head of the Crown Office, the holder of that office is responsible for all decisions taken by the Crown Office, and the Lord Advocate and the Lord Advocate alone, regardless of whether they recluse themselves from any decision, has a duty to give their view of that decision and to explain whether it was justified or not. If any holder of that office, as head of Scotland's Independent Prosecution Service, is unable to fulfil that duty, then clearly their position becomes untenable. In order to properly inform our next sessions, and in the interests of openness, transparency and accountability, the Lord Advocate must now fulfil that duty.
Thank you, Ms Mitchell. There's obviously questions in there you wish to put to the Lord Advocate. I would suggest that these are done after agenda item 3 actually starts and the oaths have been taken and we move on to this. I shall come to you first if you wish me to do that. Yes, Ms Mitchell.
Yes, I would like to put to the Lord Advocate, as head of the Prosecution Service, his view on whether it was justified for the Crown Office.
Ms Mitchell, we've been through this. We've been through this. I think this should be put to the Lord Advocate after we have moved on to the appropriate agenda item and oaths have been taken and the committee proceeds with the business of agenda item 3, and I shall call you first.
Can I just have a point of clarification, Convener? When taking the oath, will the Lord Advocate do so in the first instance, and that's a crucial point, as head of Scotland's Independent Legal Service, as opposed to appearing as the Chief Legal Officer for the Government? It's this conflict of roles which has caused a problem, so we need to be clear about that.
Can I suggest, Ms Mitchell, that under agenda item 3 you can ask these questions after the Lord Advocate has taken the oath? I am not a legal person, but I think my view is that the oath is to the person. The person is agreeing to tell the truth. So, if we wish to put that to the Lord Advocate, we shall do it under agenda item 3 when we start the committee item and when we move on to questioning. As I said, I will take your question first, and I'm sure the Lord Advocate will address it. So we'll move straight on to item 3 now. Our next item of business is an evidence session on the Scottish Government's handling of harassment complaints, where we will hear from the Lord Advocate, James Wolfe QC, and the Crown Agent, David Harvey. Can I remind all those present and watching that we are bound by the terms of our remit and the relevant court orders, including the need to avoid contempt of court by identifying certain individuals, including through jigsaw identification. The committee as a whole has agreed that it is not our role to revisit events that were a focus of the trial. That could be seen to constitute a rerun of the criminal trial. Our remit is to consider and report on the actions of the First Minister, Scottish Government officials and special advisers in dealing with complaints about Alex Salmon, former First Minister, considered under the Scottish Government's handling of harassment complaints involving current or former ministers, and procedure and actions in relation to Scottish Ministerial Code. The more we get into specifics of evidence, that is time, people, cases, the more we run the risk of identifying those who complaints. The more we ask about specific matters covered in the trial, including events explored in the trial, the more we run the risk of rerunning the trial. In questions, reference to specific dates and individuals should be avoided, and questions should be phrased in general terms where possible to avoid the risk of jigsaw identification of complainants. In addition, please do not refer to civil servants by name unless absolutely necessary, and do not refer to civil servants by name below senior civil service. I would also emphasise that the committee would be content to receive written supplementary points should any witness have concerns that their response may stray into this territory. And with that, can I welcome the Lord Advocate and invite him to make the affirmation by raising his right hand and stating. Please, Lord Advocate.
I solemnly, sincerely and truly declare and affirm that I will tell the truth, the whole truth and nothing but the truth.
Thank you. Can I also welcome the Crown Agent and invite him, please, to raise his right hand and take the oath.
I swear by Almighty God that I will tell the truth, the whole truth, and nothing but the truth.
Thank you very much. And can I now invite the Lord Advocate to make a short oath? And could I ask members to please indicate in the chat box if they wish to ask a question. Lord Advocate.
Thank you, Convener. As you have reminded witnesses and members, the actions of the Crown are not within the remit of this committee. Nevertheless, comments have been made about the Crown which are without foundation, and the public is entitled to hear the truth about these matters from me. As head of the system of criminal prosecution in Scotland, it is my responsibility to establish arrangements for the proper administration of criminal justice. And that is what I have done in relation to this case. From the outset, I put its conduct entirely in the hands of Principal Crown Counsel, Scotland's senior professional prosecutor. Like other Crown Counsel, he holds a commission which authorises him to exercise to the full my prosecutorial powers as Lord Advocate, and to do so without any reference to me. I also put in place specific arrangements so that the law officers had no personal involvement in this case. I did that to reinforce confidence in the absolute integrity of the administration of justice. And for that reason, the decisions in relation to contempt of court and other matters which have arisen since the trial have also been put entirely in the hands of Crown Counsel. Any suggestion from any quarter that the Crown's decision-making has at any time been influenced by irrelevant considerations or improper motivations would be wholly without foundation. Insinuations or assertions to the contrary are baseless. The Crown has been criticised for actions which it has taken to protect the identity of the complainers at Mr Salmon's trial, so it is important that I explain the position. The trial judge made an order to protect the complainers' identities. Any breach of that order by this Parliament, by its members, or anyone else would be punishable as a contempt of court. The Crown will seek to protect the administration of justice by advising publishers, including, if necessary, the parliamentary authorities, if it considers that a publication would breach the order. But only the court can decide whether any particular publication is a contempt, and it is for publishers to decide for themselves what they can lawfully publish. Last week, following an intervention by the Crown, the parliamentary authorities decided to redact certain evidence provided by Mr Salmon. That was their decision, and they were right to take it. Can I be clear? Any restriction on what can be published by the Parliament flows from the terms of the Court's order, and any suggestion that the Crown is seeking to limit the committee in this matter is incorrect. The Court order specifically restricts the publication of information. It does not prevent the committee from considering that information. Separately, Mr Salmon has stated that the Crown has tied his hands in respect of his use of information he holds. It is the law, not the Crown, that stays his hands. Let me be clear why the law does that. In any criminal investigation, people may provide information and evidence to the police and prosecutors of the most sensitive personal nature. It is the Crown's responsibility to treat that information with the greatest care. There are statutory provisions which oblige the Crown to disclose information to the solicitors for an accused, and that is right, that's to ensure a fair trial. Those same legal provisions prohibit the use of that material by the accused or his solicitor for other purposes. That prohibition secures the confidence of people who provide information and evidence to the police, and it protects the administration of justice. The statute contains no exceptions. The prohibition applies to information which the Crown disclosed to Mr Salmon's solicitors. Mr Salmon, like anyone else in that position, is bound to observe the law, and the Crown, for its part, has a responsibility to maintain public confidence in the integrity of this important feature of our criminal justice system. If the committee wishes to see that material, it can do so by serving a Section 23 notice on the Crown, as it has done, which will be considered in accordance with the relevant legal rules. In some quarters, the legal restrictions on the material which can be placed before or published by the committee are viewed with frustration. But those restrictions serve important public purposes. In particular, they exist to ensure the confidentiality of sensitive information and the sound administration of justice. Enforcing the law, including the law made by this Parliament, is a vindication of democracy, not its denial. And any suggestion that the professional prosecutors who are charged with these matters have been acting for any reason other than to ensure that the law is observed and to protect the administration of justice would be wholly without foundation. In his evidence, Mr Salmon has questioned the conduct of the Crown Agent who is here with me today. The Crown Agent is the professional head of the Crown Office and Procurator Fiscal Service. He is an exceptional public servant and a professional prosecutor of the utmost integrity. No one is more zealous in defending the independence of the Crown. No currency should be given to any imputation against his professional character. He has shown extraordinary leadership through a challenging period, and he has my fullest support. As Lord Advocate, I am constitutionally accountable, including to this Parliament, for the actions of Scotland's public prosecutors. Most of the decisions for which I am accountable, including in the most sensitive cases, are made by professional prosecutors without reference to the law officers. The decisions which prosecutors make may be difficult and are sometimes unpopular, but it is the job of prosecutors to take difficult decisions, and to do so without fear or favour, impartially and without regard to any extraneous considerations. They do this in the public interest, and they do so on the basis of the law and the evidence. They act with complete and utter independence. That is what they routinely do, and that is what they have done in relation to this case. They have my absolute support and confidence, and they deserve your trust too. The Crown is a central institution of our criminal justice system. By all means, hold me to account, and I am sure the committee will do so. But the committee should not entertain any attack on the integrity of the Crown or of the hard-working people who work for it. Now, I will be glad to answer your questions.
Thank you, Lord Advocate. I will start off before I go on to Ms Mitchell, the Deputy Convener. Can I ask your role, Lord Advocate, as a member of the Scottish Government is set out in the Scotland Act 1998, which was passed by the UK Parliament to create the Scottish Parliament. Can you run us through that element of the legislation and quickly talk us through your role in government and explain a little if you will, the role of the Crown Agent.
Yes, I'm glad to do that, Convener. The Office of the Lord Advocate, whoever holds that office from time to time, has a wide range of functions. Among those functions are the responsibilities of the Lord Advocate as head of the system of criminal prosecution and investigation of deaths in Scotland. And in those functions, the Lord Advocate acts entirely independently of any other person. The Lord Advocate is also, by statute, a member of the government. That was true before devolution, when the Lord Advocate was a member of the United Kingdom government, and it's been the position since devolution, when the Lord Advocate has been a member of the Scottish government. Within government, the Lord Advocate is the government's senior law officer. It's sometimes characterised as the government's principal legal advisor. The role of a law officer goes beyond the giving of legal advice. As the government's senior law officer, I am responsible, as I've explained to the committee in previous sessions, for, in effect, the whole panoply of legal aspects in the work of government. I'm supported in that by the Scottish Government Legal Directorate, by Parliamentary Counsel Office, by my own Secretariat. And I have responsibilities to help the government to maintain its commitment to the rule of law and the administration of justice.
Okay, thank you very much.
Sorry, Convener.
You paused for too long there, Roger.
Indeed, I'm sorry. I'm conscious you also asked me about the role of the Crown Agent.
Yes.
And I should say, in relation to my position as head of the system, I'm head of the system of criminal prosecution and investigation of deaths. That means that I have a ministerial responsibility to oversee that system. And as I've said, that's a function I fulfil entirely independently of anyone else. The Crown Agent is the professional head of the Crown Office and Procurator Fiscal Service, which is the organisation which fulfills the principal functions of the system of criminal prosecution and investigation of deaths. He is a senior civil servant. He is a very experienced professional prosecutor. He is the, as I say, he's the professional head of the service. He accounts to me, I suppose, as the relevant minister, and I exercise ministerial oversight of his, the fulfilment by him of his wide-ranging and onerous responsibilities. I'm sure the Crown Agent can speak for himself in terms of his role. It's perhaps important to note that he, like me, is the holder of an ancient and well-established office. The Office of Crown Agent is an independent office, and one of his responsibilities is precisely to defend the independence and integrity of the Crown in its prosecutorial and investigation of death functions.
Thank you very much. I'm sure the Crown Agent will be asked questions by the committee, to which we now move. Now, can I remind everyone that we are fairly time limited today, and we do have a lot to go through. Can I ask members who are asking questions to state whether it's to the Lord Advocate or the Crown Agent? And we'll start off with Margaret Mitchell, who will be followed by Alistair Allen. Margaret Mitchell.
Thank you very much, Convener, and can I thank the Lord Advocate for his opening statement. Both the Lord Advocate and the Crown Agent I am very familiar with in my previous role as the Convener of the Justice Committee. We have had productive and a good working relationship in the past. However, it has to be made absolutely crystal clear that the Lord Advocate, as head of our independent prosecution service, has a duty under the Scotland Act for all decisions taken in the public interest by the Lord Advocate as the head of that prosecution and by the Crown and Procurator Fiscal Service themselves. That being the case, he and he alone can answer and has a duty under the Scotland Act to answer for any decisions taken by the Crown and Procurator Fiscal, regardless of whether he recused himself or had no part in that decision. And it is on that basis today I seek his view of why the Crown and Procurator Fiscal Service, in sending the letter to the corporate body about their decision to publish the revised submission from the former First Minister, was seeking to impose more stringent restrictions on the Parliament and its ability to publish than it was deemed necessary for the Spectator to publish. Can the Lord Advocate, as head of the Independent Prosecution Service, confirm he has that duty and he alone has that duty? And can he explain if that was justified, that letter was justified, and if it is in fact justified to have or seek to impose more stringent restrictions on the Parliament's publication policy than it is for the Spectator, where what they published was exactly the same as the Parliament published. The Spectator was deemed lawful, no challenge was given or taken against them, but it was against the Scottish Parliament and the corporate body.
Yeah, thank you. Can I first of all say that it's entirely routine for me to be accountable for decisions in which I took no part. That's what I do all the time. Most prosecutorial decisions are taken by professional prosecutors without reference to me, and it is a great strength of our system that I commission Crown Counsel who exercise to the full my prosecutorial functions without reference to me. At the same time, I am entirely and solely, personally, constitutionally responsible and accountable, including to this Parliament, for all of those decisions. So I would not want there to be any doubt in the member's mind or anyone else's mind about that. Can I perhaps explain the position in relation to dealing with contempt of court matters? I think it's necessary that the public and members have an accurate understanding of the position. Any restrictions that on what can be published flow, in this case, from the court order, which has been made by Lady Dorian. It is for anyone who is publishing material to satisfy themselves, including by taking their own legal advice, what they can and cannot publish. The Crown does not give legal advice, nor can the Crown give a ruling on whether any publication does or does not constitute a contempt. Only the court can do that. And even if the Crown does not draw potential contempt to the attention of the court, anyone else with an interest may do so. That said, the Crown considers that where a potential contempt is drawn to its attention, it has a responsibility to seek to ensure that court orders of this sort, made to protect the administration of justice and the interests of complainers, are observed by drawing that issue to the attention of the publisher. That is a routine feature of Crown work, albeit more usually in the context of pre-trial publicity. It's well understood and it's well respected, generally speaking, by the mainstream media. The Crown cannot and does not, and indeed could not, proactively police all media outlets. It can only deal with issues that come to its attention. And in relation to issues surrounding the present order, the challenge which is concerned with protecting the identity of the complainer and complainers, the issue arises because of what is called jigsaw identification, the potential for different pieces of information to be put together in a way that would result in a breach of the court order. So far as what happened last week is concerned, the anticipated publication by the Parliament of the submission was the subject of representations to the Crown by complainers and their solicitors. The Crown reminded the parliamentary authorities, I'm sure they needed no reminding of the order. It was only when the submission was published that the Crown was able to assess it in full, and it formed the view that certain parts of the submission were liable to be a breach of the court order. The Crown drew those concerns to the attention of the parliamentary authorities. The parliamentary authorities took a decision, and it was a matter for them to redact certain material. Now, I'm conscious that of the point that the member has made, that other publications have taken a different view. And it's fair to say that the Crown, in dealing with those publications, was focused on particular aspects of the submission. In the context of the submission that appeared on the Parliament website, additional matters were identified, drawn to the parliamentary authorities' attention, and the parliamentary authorities took the view that they did.
Convener, can I thank the Lord Advocate for that explanation, but it doesn't explain why identical submissions were released from the Spectator and from the corporate body, yet it was only the corporate body that was subject to the Crown suggesting there may be a contempt and therefore more stringent restrictions. And the Lord Advocate explained why that is the case, because clearly that is not a reasonable or a satisfactory situation for the Parliament to find itself in when we are looking to establish the facts and look independently as a committee at what took place and to establish and receive the documents we need, which will not breach contempt of court, to carry out our remit.
Reasons I gave a moment ago, it's for the Spectator to take its own legal advice and to consider whether it should take the same course as the parliamentary corporate body. The Crown at no time gives any clearance or assurance that any particular publication is or is not a contempt for the reason that I explained a moment ago. Can I also make clear that the restriction that the court order places is on publication? It does not prevent the Parliament taking into account material that has been provided to it. So the issue is only concerned with what can be put up on the Parliament website, published to the world. As I said a moment ago, it's for publishers to form their own view as to what is or is not a contempt. The parliamentary corporate body has taken the view that it has. In my view, it was right to do so, and the decision follows from their view, and it accords with the Crown's view of the court order.
I merely say, Convener, I think people will wonder why the Crown sought to intervene in the Parliament's publication, but not in the Spectator's when it was aware they were identical publications. There will be for others much greater legal minds than mine or the committees ponder over what has been said.
Yes.
But I welcome the fact, Convener, you have allowed this discussion, and the Lord Advocate has answered in his capacity as the head of Scotland's independent prosecution.
Thank you, Ms Mitchell. I'd like the Lord Advocate give a short comment on what you just said, as I see that he tried to intervene, and then we'll move on to Alistair Allen, to be followed by Margaret Fraser. Lord Advocate.
Yeah. Yes. Can I just be clear that the Crown has not cleared or given any assurance in relation to any other publication? It is correct that additional features of the submission were identified that had not previously been identified by the Crown in the context of the submission that was put up on the parliamentary website. It's a matter for other publishers to take their own legal advice and to consider what they should be doing in order to comply with the order of the court. And all of us, I would like to think, including all members of the committee, would be concerned to ensure that nothing be done, regardless of whether there were an order of the court, to identify the complainers in the criminal trial. But as it happens, there is an order of the court and it must be complied with.
Alistair Allen, to be followed by Margaret Fraser.
Thank you, Convener. I'll address my questions to Lord Advocate, but I should say that if he wishes to bring in the Crown agent, the relevant person to answer, to include him in the conversation. Can I ask, firstly, Lord Advocate, last week the committee took evidence and there was a great deal of discussion about what Section 162 of the Criminal Procedure and Licensing Scotland Act 2010 was intended to do. And of course, my understanding is that it's not what it was intended to do that's the relevant question here, but what it says. So can I ask you to explain what that legislation actually does, what the restrictions are in it, and how it relates to the kind of materials that we're talking about in our inquiry?
I'm grateful to the member for that question. And on the first point, he's absolutely correct. Legislation is interpreted according to the meaning objectively considered of the words set out in the Act. The intentions, subjective intentions of those who passed it are neither here nor there when it comes to deciding what a piece of legislation means. This particular provision imposes a duty correctly on the Crown to disclose to an accused person information that the Crown may have gathered in the course of the police may have been gathered in the course of a criminal investigation, or the Crown may have obtained that may be of assistance to an accused person in the context of their defence of a criminal charge. That's to ensure a fair trial. But the committee will appreciate that that may oblige the Crown to disclose to an accused person, or rather to his solicitors, because I should say the material always goes to the solicitors and not to the accused person himself, to disclose to the accused person's solicitors what may be highly sensitive, highly personal information that people have made available to the police and the Crown, or may have been required to make available to the police and the Crown for the purposes of the proper administration of criminal justice. And the law therefore puts strict constraints on what the accused person or his solicitors may do with that material. What the Act says is that they may use that material for the purposes of the criminal proceedings in relation to which it's been disclosed and in the context of any appeal. And there's a provision that they may not use it for anything else, and a breach of that is itself a criminal offence. Now, it relates, as I understand it, to the issues in the committee, before the committee, because Mr Salmon has stated that his hands are tied in relation to material that he would like to provide to the committee. As I said in my opening remarks, if the committee wishes to see material, then it has a mechanism available to it by way of an order under Section 23, and indeed it was the Crown that, in correspondence with the committee, suggested that that would provide a mechanism which would allow the Crown at least to consider, according to the relevant legal rules, the provision of material to the committee. The committee has served such a notice on the Crown, and it's under consideration as we speak.
So, well, you've already set out in your answer there, I suppose, some of the reasoning around Section 162, but I just wonder, in that case, can you give a clear indication whether some of these restrictions that you're talking about would apply equally to other parties who are involved in this, say the solicitors of individuals, in the same way they would apply to the individuals?
Well, the material is disclosed to the solicitor. The solicitor is the agent of the client. The restriction would apply to the accused and to the accused's solicitor. I should say the solicitor, there are also professional obligations, as one would expect, that apply to solicitors in relation to the use of such material.
I'm going to have a little about the Spectator case here. Again, I don't know if this is one that the Crown Agent wants to offer a view on as well, but we've obviously all heard about Lady Dorian's judgment in the incidental application by the Spectator, which sought to vary the court order laid down in the case of Her Majesty's Advocate versus Mr Salmon. Can you give some indication of what your understanding exactly is about what that judgment means in terms of how Lady Dorian's decision compares to the pleas in law that were made by the applicants themselves?
Yes, and I should say that Lady Dorian's judgment is publicly available on the Scottish Court's website, so this, that it can be read by anyone who wishes to read it. As I've read that judgment, the Spectator invited the court to vary its order in two ways. One, by making a particular adjustment to the wording, and then specifically excluding from the effect of the order evidence in the submissions to the committee and various other material. Lady Dorian declined to accept the submissions of the Spectator in that regard. She made very clear that the question of publication of the committee's proceedings were not a matter for her to rule on, that her only concern was whether the order that she had made was sufficiently clear and precise in terms of what it stated. She made a very minor adjustment to the order, not an adjustment suggested by or sought by the Spectator. And she was clear that that minor adjustment did not alter the practical effect or legal scope of the order.
Thank you, Convener.
Gail, can I have Murdo Fraser, please, to be followed by Alex Cole-Hamilton?
Thank you, Convener. Good morning to the Lord Advocate. I've two substantive issues I want to pursue with the Lord Advocate this morning. But before I do that, I wonder if I could just ask about the issue of release of legal advice. As the Lord Advocate will know, this committee has for months been seeking to get sight of the external legal advice offered to the Scottish Government. There have been two votes in Parliament back at the end of last year asking the Scottish Government to release this to us, and only this week, subject to a threat of no confidence in the Deputy First Minister, has the Scottish Government now agreed to release some legal advice to us. That was intimated to us last night. Can I ask you, Lord Advocate, when did Mr Swinney ask you for your permission to release these documents to the committee?
A submission was presented to the law officers yesterday.
Thank you. So when Parliament voted for this back in November and December, there was no approach made at that time?
The position is that ministers have formed a view that the first stage of the two-part process in the ministerial code is satisfied. That's that the public interest lies in favour of of disclosure. That's at an earlier stage, ministers took the view that it was not in favour of disclosure, that public interest did not favour disclosure. Ministers have now reached that view. The question of law officer consent in terms of the ministerial code only comes into play at a point where ministers are satisfied that the first stage is met.
Okay, thank you. That's very helpful. I think we might deduce from that what changed ministers' mind was the threat of a vote of no confidence rather than any other factors. But that's something we'll leave for the time being. Can I ask you, are you... Sorry.
I was just going to say that's clearly not a matter I'm going to comment on.
Indeed, fair enough. Can I ask you, are you aware of the content of the legal advice that will be supplied to the committee? Because we have not yet seen it, and as I understand it, we will not see it until this afternoon. The committee passed a motion unanimously in the name of Andy Whiteman at the end of last year, specifying the documents we require to see. Do you know if what we are going to see will meet the requirements of that motion?
I'm afraid I can't say one way or the other. I'm aware in general terms of the material that is going to be released, but how it relates to the particular terms of the motion, I simply can't comment.
Okay, thank you. Time will tell. Can I move on? I want to raise this issue that Alistair Allen pursued with you a few moments ago about the application of Section 162 of the 2010 Act. And the reason this is significant is that in his evidence to us on Friday, Mr Salmon made some very serious allegations that there was in effect a conspiracy against him by senior people in the Scottish Government and in the Scottish National Party. And evidence to support these allegations is contained in documents that his lawyers currently hold, but he cannot release to us as a committee because the operation of Section 162 of the Act would make it a criminal offence to release them to us. So can I just ask you, so we're clear, do you as the Lord Advocate have discretion as to whether or not Section 162 can be waived in a case such as this?
Well, there are no exceptions to the provisions of the Act.
There have been no civil cases. There have been no civil cases that you are aware of where you have agreed to waive the application of Section 162 to allow evidence presented in a criminal case to be utilised in those civil cases.
In the claims against me by Mr Clark and Mr Whitehouse, the question of the use of material that had been disclosed to them for the purposes of initiating a claim against me had to be addressed. The issue was dealt with through them taking a legal case to the applying to the nobile officium of the court. That's an exceptional power that the court may exercise in particular circumstances. And through that process, the matter was dealt with so that they could use that material for the purposes of initiating a claim against me. So a wholly different situation, and one in which the matter was dealt with in the way that I've just described.
Thank you for that. So when you said to us there were no relevant exceptions, in fact what you meant was there are relevant exceptions if the case is pursued in a particular way. You see, the reason I ask these questions, Lord Advocate, is that we know that in the Whitehouse and Clark case, Section 162 was set aside to allow access to these documents presented in a criminal case to be used in a civil case. So we know there is an exception. That's already been established. And there are people who claim that the Crown Office is part of a cover-up, together with the Scottish Government, in not allowing this information to be provided. So given that we have a precedent for this having been done already, why is it not being allowed in this case?
Well, first of all, that's a wholly different set of circumstances. It was dealt with through the process that I've just described. Can I say absolutely that the Crown is not party, would not be party to any improper conduct. Can I just say in relation to the material, as I understand it, we're concerned here with material which was not admitted into evidence in the course of the criminal proceedings. I have not myself seen the material, but I think one can take it that it was not admitted into the criminal proceedings because the trial judge, Lady Dorian, took the view that it was not relevant to the issues in the criminal trial. And one can draw one's own conclusions as to the bearing that the material would or wouldn't have had, but one could take it that it was not relevant to the issues in the criminal trial. The committee can obtain this material by serving a Section 23 order on the Crown, and the Crown itself, in correspondence with the committee about the release of material, recognising that there are legal constraints on the Crown about its own use and its own disclosure of sensitive information, identified to the committee Section 23 as providing a proper legal basis. So it's in the hands of the committee to initiate those processes. As I understand it, the committee has served a Section 23 notice on the Crown last week, our second one. The committee served an earlier one to which the Crown responded in full. It's considered at the moment. So I reject absolutely any suggestion, any attack on the integrity with which the Crown has conducted itself in relation to these matters. And I should say, as I said in my opening statement, these matters have been put entirely in the hands of the most senior professional prosecutors in Scotland, and any suggestion of improper motive or improper behaviour is the most serious slur on their professional character and integrity, and it should not be entertained for a moment by this committee.
Thank you, Lord Advocate. We have, of course, as you say, served a Section 23 notice on the Crown Office. Mr Salmon was also suggesting that we serve a Section 23 notice on his lawyers, who already hold this material. If we were to do that and recover the documents, and if they were relevant to our inquiry, would the Crown Office have any objection to us publishing that information?
I'm not going to comment on that on the hoof. That's something that would require to be considered.
Okay, thank you. Can I move on, Convener? I've got one more issue I want to cover off, which is important and was also raised in the evidence from Mr Salmon, and that is in relation to the recovery of documents which were held by the Scottish Government. Mr Salmon was at pains in his evidence to discuss the duty of candour that applied to the Scottish Government, and how a search warrant was applied on the government in October or November of 2018, asking for details of contact between the Permanent Secretary and the complainants, and information was not disclosed by the Scottish Government pursuant to that search warrant, which would be an extremely serious matter were it to be true. Are you able to confirm whether Mr Salmon's evidence in this respect is accurate?
It's been reported. I've seen the reports in that regard. I may say that although the Crown Office has been in touch with Mr Salmon's legal advisors in order to clarify what is being suggested, to date the Crown Office has not received any letter from him or his solicitors identifying the basis of his concerns or identifying documents which he claims, and it's important these are only claims, I express no view on them. He claims Scottish Government failed to disclose in response to the search warrant. So Crown Office is unaware of the detail of the complaint. If the Crown Office receives any correspondence in that regard, it will of course consider it carefully before determining the way forward.
A search warrant was served on the Scottish Government, and the Scottish Government did not comply with it and did not reveal information that they held. What would be the sanction?
Well, that's something that would require to be addressed by the Crown if and when it receives details. I should say that I should not be taken as accepting or indeed commenting one way or the other, or accepting the suggestion that the government did not respond to the search warrant. As I understand it, there was that was a particular process, but it was dealt with carefully. A commissioner was appointed to look at material and so on and so forth. So I'm not to be taken in any way as accepting the claims, but if the claims are articulated to the Crown, then the Crown will, of course, look at them.
And that would be a criminal matter?
Depends on the circumstances, and I'm not going to speculate in anticipation.
But it could be a criminal matter?
As I say, it would be entirely wrong for me to speculate in the abstract about this.
Well, let me ask you then, on a hypothetical situation, would failure to comply with a search warrant in these circumstances be potentially the committal of a criminal offence?
As I say, I'm not going to discuss in the abstract what might or might not be a criminal offence. Failure to comply with a search warrant is clearly something that would require investigation, and it would be a serious matter that if it were to have taken place. But I am not going to make any comment in the abstract on what might or might not be a criminal offence.
But I mean, Lord Advocate, with respect, you're head of the prosecution service in Scotland. I'm asking a very simple question. Is failure to comply with a search warrant a criminal offence in Scots law? Yes or no?
Well, one would have to look at things like the motivation, the circumstances. I am not going to comment in the abstract because I know exactly what I'm afraid what the member is seeking to lead me to do, and I'm not going to be led into it.
Okay.
Particularly, I should say, when, as I say, the Crown has not been cited on the detail of what it is that's alleged.
Okay. Before I bring Mr Cole-Hamilton in, David Harvey, our agent, would like to say a few words. Mr Harvey.
Thank you, Convener. Just two matters related to Mr Fraser's second question and then his final question, if I might just add one further comment. So in relation to the second question and the serious matters which he identified as being raised in Friday's session, just remind members that these matters were investigated by the police. The evidence was gathered by the police. It was assessed by the police. It led to charges being brought that were submitted to Crown Office, and there was thereafter a specialist recognition team of experienced lawyers who considered that material, and it was thereafter considered by independent Crown Counsel. The material upon which the comments were made was actually material that was disclosed by the Crown and was thereafter put for consideration before the court and was ruled upon by Lady Dorian. And so I think it's important that the committee has a clear understanding of the nature of the material in terms of where it has been gathered, who it has been gathered by the police during their investigation, disclosed by the Crown and considered by the court. And finally, just very briefly in relation to Mr Fraser's final question there, if and when we get clarity in relation to what is said to have happened, then that is a matter that will be considered seriously.
Thank you. Can I move on now, please, to Alec Cole-Hamilton, to be followed by Andy Whiteman.
Thank you very much, Convener, and good morning both to the Crown Agent and Lord Advocate. I have a number of questions for the Lord Advocate first, and there is, I think, scope for the Crown Agent to come in on a couple of questions I've got. But I'd like to follow up briefly, if I may, on Murdo Fraser's line of questioning around the search warrant. Lord Advocate, the search warrant was served on the government, particularly for the discovery of documents to evidence contact between the Permanent Secretary and the complainants. That really goes to the very heart of this, and indeed the issues we're looking at around bias and about whether the process was applied appropriately. Can you explain how you advised the government on the satisfaction?
Sorry, I lost the last part of Mr Cole-Hamilton's question.
My apologies. I was asking, Lord Advocate, what advice, if any, did you offer the government on the satisfaction of that search warrant?
Well, as I'm afraid the member will recall from previous sessions, the question of who has tendered any particular advice to the government in relation to any particular matter is not something which is any minister would disclose. What I can say is that that the government, of course, had legal advice in relation to the search warrant and was indeed represented in dealing with the search warrant matter.
I understand. Thank you. I'd like to move on. We know that at the end of the government's investigation, the Permanent Secretary passed a number of allegations over to the Crown Agent following passed the report and findings to the Crown Office. But this was against the wishes of the two complainers. One of the most striking allegations that Mr Salmon makes in his final submission is that you, Lord Advocate, actually instructed witness statements from those complainers. They were reluctant, but you asked them to give police statements to support the findings of the investigation. Would you like to respond to those?
Yes, I've made this clear in correspondence to the committee. I'm not sure what power it's thought I would have to give such a direction. I can be clear, I at no time gave any such direction.
Okay, that's helpful. I'd like to move on then to, in terms of the decision, and maybe perhaps this is a question for David Harvey as Crown Agent. In terms of determining what is investigated when complaints are made, we have two relatively recent issues. There was all connected to our investigation and the work of our inquiry. We know the Crown Office is pursuing currently the leak of the WhatsApp messages to this committee in respect of they were, I think, WhatsApp or text messages in the name of Peter Murrell. These are the messages around putting pressure on the police. But no such action has been taken around the leak to the Daily Record, which arguably has more public interest in terms of protecting the anonymity of complainers. Can you explain how that decision was taken?
If that's directed at me, in the first instance, I'm happy to make this point that that leak was investigated, as I understand it, by the Information Commissioner's Office, which is the investigating authority which is charged by statute with investigating matters of this sort. As I understand it, the conclusion from the Information Commissioner's Office was that they basically there wasn't the evidence didn't support the identification of any particular individual, and in those circumstances the matter couldn't proceed any further.
Okay. Thank you for that.
Can I interrupt, Mr Cole-Hamilton? Mr Harvey would like to come in on that particular point.
I was hoping you would. Thank you.
Yes, Mr Harvey.
Thank you, Convener. Thank you, Mr Cole-Hamilton. Just to be clear, and again, it's one of these things that perhaps it's helpful to explain for public understanding, is that in Scotland we have what's called a unitary prosecuting authority. So unlike other countries where there are perhaps multiple prosecuting authorities, In Scotland, there is only the one, and so therefore there are a number of agencies that report in allegations, whether that's obviously the police, HMRC, and others, including local authorities. And one of those is the Information Commissioner's Office. So in Scotland, had that Information Commissioner's Office identified in its investigation criminality, then that report would have come to the Crown Office for consideration.
Thank you.
Thank you, that's very helpful. I've just a couple of very minor follow-up questions. I think the first is definitely for the Lord Advocate, second, I think more appropriate for the Crown Agent. Lord Advocate, you have a dual role. You're the government's lawyer, effectively, but you're also the head of the prosecution service. As head of the prosecution service, you've got to act in the public interest, but as government's lawyer, you act as in the government's interest. Those tensions, those roles clash. There is a tension between. Can you tell us how you decide which takes preeminence?
Sorry, again, I'm afraid I lost the end of your question. I'm sorry, Mr. Cole-Hamilton.
We're beset by gremlins. No, I was asking about the tension that exists in your dual role between acting in the government interest as the government's lawyer and in the public interest as the head of prosecutions in Scotland. When those tensions collide, when those roles collide, which interest takes preeminence? Which is more important, government interest or public?
Can I start by making this observation, that the office which I hold has combined these various functions ever since devolution and long before it. Other models are available, but this is the model we have, and it's the office which I hold. And I think any suggestion that it cannot be held with integrity is wrong. I've been living in this office for the duration of this Parliament, and I am satisfied that the different responsibilities and functions can be combined with integrity. Although, as I say, other models are available. The bottom line for me is that my only responsibility is to the rule of law and the administration of justice. That's my function, my fundamental, the sort of fundamental principle that underpins all the functions that I have, whether they are functions within government, in terms of being the government's senior law officer, or whether they're the functions I have that sit with me and with me alone. And once that is understood, any apparent tensions are resolved, because the overriding touchstone is what is the correct thing to do, what is the right thing to do in terms of the rule of law and the proper administration of justice in Scotland.
Okay, thank you. And this is my final question, convener. And really, both panelists feel free to answer this. But this is a process question. If you are watching evidence given to our committee under oath, and you see a witness saying something that you know to be false based on evidence that you have, perhaps that this committee has not seen, is it not true that a crime is being committed in that regard? And how would you then, what action would you take if you were aware that a false statement had been made to this?
Well, again, I don't think it'd be right for me to comment on a wholly hypothetical situation.
Okay, but I'm not asking about a hypothetical here. I'm just asking about, as a matter of process, is that something that you would just spontaneously start to investigate yourself, or would a complaint need to come forward from somebody who suspected that a false statement had been?
Well, with all respect, Mr. Cole-Hamilton, you're putting a hypothesis to me. The issue is hypothetical in the sense that, it's clearly hypothetical in that sense, and I think it would be wrong for me, with the various, with the functions that, as I've just described them, to be drawn into commenting on particular hypothetical situations.
I think David Harvey wants to come in, convener.
Thank you, Mr Cole-Hamilton. So there is obviously relevant legislation, etc., under which complaints could be brought, and just in terms of the reality, it's not something that we do in terms of with the best will in the world, sitting watching every parliamentary session with a view to policing that, and I say that with the greatest of respect. It's simply not our role to do so. So therefore, since we are into the realms of the hypothetical, the reality is that it would be a matter for others to draw to our attention.
Thank you, convener.
Okay, thank you. I have Andy Whiteman to be followed by Jackie Bailey.
Thank you very much, convener, and welcome, Lord Advocate and the Crown Agent. I should just declare for the record that I'm a member of the corporate body and therefore aware of the correspondence that has taken place between Crown Office and the corporate body. Lord Advocate, I wonder if you could clarify something you said in your opening remarks, that it is the job of the Crown Office to advise publishers in relationship to contempt of court, but you then went on to say that you don't provide legal advice. I understand there obviously is a distinction, but can you just clarify that your role in advising publishers goes no further than drawing to their attention concerns that you have as to the possibility that a contempt might be being committed?
Yes, I'm really grateful to you, Mr. Whiteman. I mean, that's exactly right. I thought I had said that it's not the Crown Office's role to advise publishers. But the Crown Office, as I explained, in order to protect the integrity of the administration of justice, will draw to the attention of publishers any concerns that the Crown has about the terms of any publication. It is for the publisher then to take its own legal advice, and ultimately only a court can decide whether a contempt has been committed. A publisher could, on its own legal advice, take the view that the Crown is wrong and take run the risk, take the potential that that it may have to be argued in court. Equally, the Crown simply cannot and does not purport to police the media. It relies in this regard on matters being drawn to its attention. If things are drawn to its attention which give rise to a concern about contempt, then it will very properly raise them with the publisher, and the publisher will then have to consider what the right thing to do is.
And in respect to that, can I ask you whether you have indeed raised any further concerns to the Spectator magazine, further to the correspondence you had with them on the 15th of January this year?
I'm afraid I'm not aware of the current position in relation to the Spectator. I can perhaps follow that up with the committee if that would be helpful.
That would be very helpful. Furthermore, on the question of contempt, do you accept that there's been limited litigation in this field, that it is difficult to understand where the lines are drawn in relationship to contempt? For example, on a spectrum where no one says anything at all about anything that has any bearing whatsoever on the matter, and you've got complete opaqueness. The other end of the spectrum, where you publish the names of the complainers on the front page of a newspaper, there is a substantial grey area that may be a differing length, and it's hard to know often for publishers to know where the line is that they may be crossing. So, for example, would information lead to one person identifying a complainer through Jigsaw? Would it have to be 100, 1,000, etc.? Do you accept as a general principle that the law in this area is unclear and might benefit from guidance, perhaps from the Crown Office or others in future, particularly where it engages a Parliament, which has very specific responsibilities, in order to better understand the parameters of what might constitute contempt in any particular case? Yes.
I think the touchstone here has to be the terms of the order in this case. Contempt issues usually more usually arise in the context of pre-trial publicity, where there are particular rules and where the Crown from time to time raises issues with publishers. You're absolutely right, Mr Whiteman. There's been little litigation in this area, principally because the media understands those rules and is, generally extremely respectful of the need to comply with them. In a case like this, I suppose the starting point is the terms of the court order, which is an order preventing the publication of the names and identity and any information likely to disclose the identity of the complainers in the particular criminal case, with now the addition of the words as such complainers in those proceedings. I appreciate the point that the member is making, that at one end of the spectrum would be a publication that named individuals and said that they had been complainers in the criminal proceedings, an absolutely clear breach of the order. And the difficult areas arise where information is published which, put together with other information that's in the public domain, could identify those complainers. Now, that's a well-recognised. The order can be breached by doing that. I think one needs to be very clear that the publication of information which, put together with other information in the public domain, would identify the complainers, is a breach of the order. And I appreciate that it is difficult for publishers, as it is for the Crown, because the Crown the Crown is not monitoring the media. The Crown, has to proceed on the basis of matters that are drawn to its attention. But I'm afraid, it's the responsibility of publishers in this area to consider carefully what they're publishing. They know the terms of the order. It's for them to, on the basis of their own legal advice, take a view. The Crown, as you correctly pointed out, will draw any concerns it has to the attention of publishers. The Crown cannot give a clearance or assurance, precisely because it's not itself monitoring the media as a whole. Whether the law itself needs clarification, or whether it's some of the practical challenges of complying with the law, is perhaps a question. What one would hope is that all publishers, in good faith, would be seeking to avoid, at any cost, putting themselves in a position where they disclose the identity of complainers in a criminal trial, both because it would be a breach of the order, but also because it would be the wrong thing to do.
Thanks very much. Can you just confirm, as a matter of law, that, for example, a publisher in Germany is not bound by the court order?
I don't think it'd be wise for me to comment on German law.
Okay, thanks. Moving on to the Criminal Justice and Licensing Act 2010, Section 162. If one can characterise this 162 as a deep freeze into which material is put and can only be extracted if the grounds of subsection 3 are met, or indeed, as the case you noted, the Office of the Noble Officium Court can access the deep freeze. Can you explain the terms under which, and that this was revealed in the Information Commissioner's report, there was a meeting on the 21st of August, and there was a statement made by Detective Chief Superintendent, whose name we don't know, in relationship to the handling of the internal misconduct investigation of the Scottish Government. That was provided by Levy and McRae to the Information Commissioner's office. Is it correct that their ability to do that was because of Section 131 of the Data Protection Act 2018?
There about whether it was followed from that particular provision. What I can say is that whilst the Crown was advised of Mr Salmon's intention to disclose that statement to the Information Commissioner's office, it did not consent to that. And I suppose there are 2 points to make. That was the passing of one specific piece of information to an organisation charged with investigating what was a potential criminal offence under the Data Protection Act. You maybe have the advantage of me in having the section in the Data Protection Act in front of you, Mr Whiteman. I'm afraid I don't. No, I'm afraid I don't either.
No, that's fine. We'll leave that. But to be clear, you didn't consent to that disclosure to the Information Commissioner Office?
No.
Okay, so that contradicts Mr Salmon's statement in column 10 of the official report, where he says that the reason we were able to give the ICO a copy of that statement is because the Crown Office permitted us to do so. That's not correct in your view.
Well, I should be clear. I'm told it was mentioned at a meeting between representatives of the Crown and representatives of Mr Salmon that they intended to do that. The Crown, noted didn't make any comment one way or the other, as I understand it.
Okay, thanks very much. And if I can just conclude, convener, in relationship to that meeting on the 21st of August 2018, and this is a question to Mr Harvey. 21st August 18, Detective Chief Superintendent redacted was at that meeting. This was a meeting where the police were offered a copy of the internal misconduct investigation. They refused to take it, and at that meeting the Detective Chief Superintendent also voiced concerns about the Scottish Government making a public statement about the outcome of their investigations. Were you present at that meeting, Mr Harvey?
Yes, I was, Mr Whiteman. Would you like to know more about the meeting?
I would, please. Thank you.
So you're quite right, it was the 21st of August 2018, just in terms of members' understanding of the timescales and the chronology of events. And in attendance were, aside from myself and the Detective Chief Superintendent, also in attendance was the Chief Constable. So candidly, in the room you had the best part of 90 years criminal justice experience in the room. The meeting took place in the morning, and earlier that morning I had received a small bundle of hard copy material at my office, which is where the meeting was held, and that hard copy material had come in from the Scottish Government. Broadly speaking, there were 3 parts to the material. There was a covering note, there were some statements, and there was a report. In the short time available, I read the note, I skimmed the statements, and I noted that there was a report. I did not read that report, and I have never read that report. When they arrived, I apologised for the short notice of the meeting because it had been arranged the day before, and both were entirely content and entirely appreciative of why they were there and the sensitivity of the issues that were going to be discussed. I explained to them what I had received and that we would need to discuss a variety of issues, which we did, including in relation to the report. The Chief Constable and the Detective Chief Superintendent skimmed through the note and the statements, and we agreed that there would be an investigation at that stage into what is simply at that point potential criminality, as you would expect of any law enforcement agency or any prosecution service across the world in receipt of such information. The priority, we agreed, was to establish early contact with those who had made the complaints, because it was understood that they were anxious, and we agreed points of contact because of the sensitivity of the issue to ensure that investigations which were being instructed were held as tightly as possible, and a discreet police team was to be set up. We turned to the report, and there was a discussion about, frankly, what was to be done with it. 90 years of experience, I have no monopoly in the wisdom in that room. I hadn't read it, and I told them that. I said we had it. If there was to be a subsequent prosecution, and bearing in mind that at that stage this was investigation into potential criminality, but if there were to be a subsequent prosecution, then it would have to be to be considered for disclosure, because I had it. And thereafter, there was a discussion about what, if anything, we were to do with it. And during that discussion, the Detective Chief Superintendent suggested that the police not take it at that time. and everyone was comfortable with that. And we moved on to discuss other arrangements, including the communications suggestion from Scottish Government that there was going to be some communication message as yet at that stage undefined. And it was a clear preference in the room that there would be no reference at all to the matter being remitted to the police in any announcement. The meeting concluded, the report was secured safely, and I have not read it to this day.
Okay, thanks, Mr Harvey. That's a very helpful summary. Can you just confirm that, as the ICO report notes, it was a Detective Chief Superintendent who voiced concerns about the Scottish Government making a public statement? For the record, were any of the other parties expressing any concerns, or was it just the DCS?
No, there was she did raise that, and again there was no disagreement on anything in the room in relation to that, and or any other matter in relation to how matters were to be handled.
Thanks. And can you just confirm that the material that you came into possession of that you were discussing there came into your possession because you were sent it by Leslie Evans, the Permanent Secretary, the previous day?
I think it came in from, so it was hard copy material. It arrived that morning, and the letter that I received was signed by someone else who's given evidence in this committee, if you're content that I name the person. Convener's nodding, yes. I think from recollection it was signed by Nicky Richards.
Okay, thanks very much. And just to confirm, it was you who arranged this meeting with the Detective Chief Superintendent and the Chief Constable, is that correct?
I called the Chief Constable it was late afternoon, early evening before.
Okay, and finally, I'm sorry, Convener, one final question for the Lord Advocate. In relationship to the disclosure of this material to the Crown Agent, Leslie Evans, the Permanent Secretary, said that she took legal advice as to who she should disclose it to. Having decided, as I understand it, to disclose it to law enforcement, it was decided not to disclose it to the police, but to disclose it to the Crown Agent. Can you say anything more about why that was? Is this a convention whereby Scottish Government, as a matter of routine, does not report alleged crimes straight to the police, or why did it go to the Crown Agent?
Yes, I mean, I can comment on that. I think the starting point is, of course, to recognise the extreme sensitivity of the matter, very unusual situation for government to have concluded that it should refer a potential criminal allegation to the police. The question of how that should be done in order to ensure that from the outset it was handled with the care and integrity that such a matter required needed very careful thought. I had a discussion with the Crown Agent on an entirely anonymous basis, without identifying the potential suspect. At some point ahead of the meeting that the Crown Agent has described, to take his advice as to the best way in which government should refer allegations of potential criminal conduct by a former minister to the police in order to ensure, and I emphasise this, that the matter would be handled with the utmost integrity and the sensitivity that any such allegation required. And the key point, of course, was to make sure that at the point when the material came into the hands of the police, that it came into their hands at the appropriate level and in a context where from the outset arrangements could be in place to protect the interests both of the potential suspect and of any complainers. And I should make clear that at that stage, at the stage of that discussion, I did not disclose to the Crown Agent the identity of the individual concerned, and the upshot of that was a view that I reached as head of the system of prosecution, that the correct way to proceed to ensure the integrity of the process was for the material to be passed to the Crown Agent on the basis that he, because he deals operationally on a routine basis with the police at the highest level, that he could ensure that arrangements were put in place from the outset of the sort that I've described. I then, the government then, followed that procedure, and the Crown Agent has described how the material came into his hands. And I should say that the committee should be very clear that at the point where the material passed from Scottish Government to the Crown Agent, it was in the hands of the independent law enforcement and prosecutorial authorities who work closely together in relation to any serious allegation of criminality. And from that point, myself and the Solicitor General took no part in the work of the Crown on this particular case. So it was a carefully considered process designed to recognise the sensitivity of the matter, to protect the interests of the potential suspect, and to ensure that the interests of the complainers were respected from the outset. And perhaps I can just make this point, that one perhaps has to consider what the alternative approaches might have been. No doubt there could have been an approach directly to the police. The Crown Agent will have his own comment on this, but I suspect if the police had received an allegation of this sort and this sensitivity, the first thing they would have been doing would be to speak to the Crown to ensure that both the Crown and the police had arrangements in place to recognise the particular character of this case. And the committee may, or some members of the committee, I'm sure, will be aware that in Scotland it is not unusual for the Crown to be involved from the outset in the more serious and sensitive cases, and as required to be giving directions and advice to the police. So that's the background and the genesis of the what was done. And can I just say that there is nothing untoward in those arrangements. They were put in place for good reasons. They were successful in achieving what was intended. And in relation to the passing to the across of the government report, again, no criticism at all of either of the Crown Agent or the police in the very careful way that they approached that, but equally nothing untoward in that being tendered. If one steps back from this particular case and perhaps thinks about an investigation by an employer into allegations that an employer concludes required to be passed to the police, one could readily envisage the employer giving the police whatever written report the employer had put together. That would no doubt help to inform the police. Ultimately, it's not primary evidence, it's not admissible evidence in itself. The police will carry out their own investigation of the matter, and the Crown Agent has already explained to the committee that, of course, there's an investigation. The police gather primary evidence. The evidence is assessed by the police. A report is made to the Crown. It's considered and analysed by the professional and support staff in the Crown to put together a document and supporting material called a recognition, which is a full description of the case and an analysis of the primary evidence. That material is then submitted to independent Crown Counsel, who reaches the decision, makes the decision about whether the evidence supports criminal charges or not, and if so, whether a prosecution should be brought, and if so, on what charges. The idea that process, the outcome of that process would be affected by the receipt in any context of a report of the sort that we've heard here, I think is simply incorrect. Doesn't stand any scrutiny at all.
Thank you. Thank you.
Are you complete, Mr Whitney? Right, Alex Hamilton with a very short supplementary, please, on something that he's heard in that evidence.
Thank you for bringing me back in, convener. No, it was a very useful section of questioning, but something jarred in your answer, Lord Advocate, with something you said earlier. You said in your answer to Andy Whiteman just now, you were acting in the interests of the crowd. But the government passing the report to Crown was against their wishes. They'd said they didn't want police involvement. You've strenuously denied the allegations of Alex Salmon, saying that you instructed them to cooperate. So I just wonder if you can explain how the complainants were persuaded to cooperate with the police investigation, given that it was against their wishes.
Well, I mean, the first point is I think the Permanent Secretary may have given evidence about the reasons why the matter was referred to the police, the decision that was made in that regard, and why, notwithstanding the views of the complainers, the government concluded that it was the right thing to do in this case, that the matter be passed to those charged with investigating allegations of criminal conduct. Thereafter, of course, it was a matter for the police to speak to the complainers, and the Crown Agent touched on that. I can't, I'm afraid I can't comment on that interaction, and I'm not sure that it's something that it's appropriate to explore.
Thank you. Mr Harvey would like to come in on this.
Thank you, convener. Just very briefly on that point, it was a matter for individuals as to whether and to what extent they cooperate with the police investigation, and so it's establishing, from the police's perspective, contact with them with a view to seeking their cooperation. It's not a decision that's taken by others.
Thank you. Can I now move on to Jackie Bailey, please? And could I also ask my Deputy Convener, Margaret Mitchell, if she would take over the chair for a few minutes? Thank you very much.
Thank you very much, Convener, and good morning to Lord Advocate and the Crown Agent. Just a couple of things I want to explore before I move on to my questioning. And let me start with the Spectator article, because I think the Lord Advocate, in referencing this, said that there would be no clearance or assurance given by the Crown. But I'm wondering whether that is strictly accurate, because in a pre-meeting before Lady Dorian's hearing between Levian McRae and Alex Prentice QC, my understanding is Mr Prentice said that there were no other concerns with the Spectator article. Is that correct?
Well, my understanding is that at the in any discussion of the Spectator article, there was particular focus on a particular paragraph of the article. I can't speak to precisely what was or was not said in that meeting, but what I can say is that the Crown cannot give a clearance or assurance, because it's not in the Crown's gift to determine whether or not a particular article is or is not a contempt. And that's well understood by publishers, that they have to take responsibility for their own publications. Now, at that, as I understand it, at that meeting, there was the particular focus was on a particular paragraph when the matter was revisited, I suppose, in the context of the material that was published on the Parliament's website, additional areas of concern were identified by the Crown. Those were drawn to the attention of the parliamentary authorities, and the parliamentary authorities took the view that they've taken.
Ms Bailey?
Oh, thank you. The Lord Advocate, just like myself, we weren't in the room, so we can only guess at what went on, although we've been written to by Levy and McRae, and I think this exists in our papers, and there is a suggestion that Alex Prentice QC said there were no other concerns with the article. Now, it is true that you haven't written as the Crown Office to the Spectator since the 15th of January. Is that correct?
Well, I don't know if the Crown Agent can help me with that. The Spectator will no doubt have been watching events. It's for the Spectator to form its own view about about what it may lawfully publish and what it may not lawfully publish.
I absolutely understand that, but what I'm suggesting is, given that the Crown Office hasn't written since the 15th of January, don't think clearly by your actions there's any urgent need to get the Spectator to redact more. And the reason I'm pressing that point is, the paragraphs that you sought to get redacted from the Scottish Parliament's evidence on its website are remarkably similar, if not identical, to the ones that people can see today on the Spectator website.
Well, as I've said before, the Spectator, I have no doubt, and its legal advisors will have been watching, observing what's been happening. They are well aware of the position one may take it. It's for them to consider what they may lawfully publish and what they may not.
Okay. You've just said to us, Lord Advocate, you knew about the complaints. Could you tell me when you were first told and who told you, and that you directed the Permanent Secretary to hand the material to the Crown Agent? Did I pick you up correctly on that point?
Sorry, can I just be clear what you mean about by way of the complaints?
So you knew about the complaints coming in. You said just previously that you'd had a discussion with the Crown Agent without naming who the complaints were about. So I'm just clarifying that you knew about the complaints, you'd been advised about them. I'm asking when and by who. And you also said you directed the Scottish Government, I'm assuming in the person of the Permanent Secretary, to pass that information to the Crown Agent.
Well, I was clearly aware that complaints had been made. I can't now remember precisely at what point. I was concerned, being aware that, and also that consideration was being given to referring this matter to the police. I was concerned to ensure that arrangements could be put in place to ensure the integrity of that process, and that's the context for the discussion which I mentioned a moment ago.
Sure. Could you maybe think about when you found out? And certainly you haven't addressed the question of who told you, because it's quite a significant moment. I would certainly remember it. And I wonder, with a bit of time, whether you would reflect on that and write back to the committee. Could you tell us when you recused yourself from the criminal case against Mr Salmon?
As I made clear a moment ago, arrangements were put in place from the moment when matters were passed to the Crown Agent, so that neither I nor the Solicitor General for Scotland were took any part in the Crown's work on the case.
Okay, thank you. Can you explain why then an instruction was issued that two reluctant and unwilling complainers must provide statements to the police? And if you didn't do it directly, then who did it on your behalf?
I simply don't know whether the factual premise is true.
Okay, well, let me tell you, in evidence to this committee from a civil servant, it was noted that you had intervened and wanted complainers to make statements to the police. Did she imagine that?
I've given no such direction.
Okay.
Nor would I have power to do so.
On your behalf, Lord Advocate?
I'm not sure what power it's thought that under which any such directions could be given.
Okay, you can see how troubling it is when you're saying that, and I absolutely believe you, that a civil servant is saying to the complainers, a senior civil servant, that the Lord Advocate wants you to make statements. You know, that's pretty powerful stuff, but you're saying none of that is true. So actually, the complainants might have been misled.
Well, all I can say is I gave no direction and would have no power to direct someone to give a statement. I'm not, I have to confess, I'm not familiar with the evidence to which you're referring.
Okay, thank you.
Can I say at this point that that the Crown agent has indicated he may want to come in?
Can I ask him to hold that, because I have questions to the Crown agent?
I'll just point that out, that at the end of your questioning, I will give the Crown agent the opportunity to come in.
Perfect, thank you, Deputy Convener. Lord Advocate, did the Crown Office, when whoever it was issued the instruction to the complainants that they needed to provide statements, did anybody consider the distress and upset that this would have caused them?
Sorry, I slightly lost you, Miss Bailey. Would one of you could repeat the question?
Of course. I'm thinking about the complainers, as we all should do, and I'm wondering whether, given that they were unwilling, whether anybody considered the distress and upset that would be caused to them.
Yeah, well, I think the Permanent Secretary has explained the government's reasons for making the referral, notwithstanding the views of the complainer. And can I say that that's an issue that engages prosecutors all the time. The Crown agent has explained that once the matter was referred to the police, it was a matter for the complainers to decide to what extent they wish to cooperate with the police investigation or not. That was entirely a matter for the interaction between the police and the complainers.
Now that Mr Swinney appears to be giving the committee all the legal advice that we've been asking for, can you confirm that you gave legal advice to the government on assisting the judicial review in September 2018? And if that was the case, can you confirm that we will receive this advice as well?
I'm not going to confirm the involvement of any particular lawyer in the giving of any particular advice at this stage. I can confirm that the government considered at the outset of the judicial review process whether steps should be taken in relation to that process in order to avoid the risk that publicity attendant on the judicial review might prejudice the criminal investigation. And that consideration included the question of whether the judicial review should be assisted, that's put on hold essentially, and also whether the matter could be dealt with adequately by restrictions on reporting of the judicial review. I should say that at that point, as I think I advised the committee at an earlier session, the government was dealing with the petition as originally presented. It considered it had good grounds for resisting all the allegations made in that petition. By the end of September, Scottish Government reached the view that the issue of the interaction between the civil and criminal process could be adequately dealt with by reporting restrictions. That was a matter of agreement with Mr Salmon's legal team. They enrolled a motion which was the government didn't oppose for the placing of reporting restrictions on the judicial review. The government didn't need to be represented at that hearing because the matter was not controversial. Entirely, I should say, it's entirely normal, entirely appropriate where there's an interaction between a civil case and either a criminal investigation or possible criminal proceedings in due course to consider how that can be regulated in a way that avoids any potential risk to any future criminal process. And that's precisely what was done.
Thank you. I wasn't asking for a particular lawyer, but you've confirmed that the government gave legal advice on the assisting of the judicial review. I would note that the motion to protect anonymity, it delighted the government didn't oppose it, but you didn't appear for it, which is slightly disturbing. Can I turn to events of last week where you told me in the chamber that you hadn't approved the letter from the Crown Office to the Scottish Parliament's corporate body, and you only had sight of it after it was sent. Why weren't you asked for any guidance or direction from Crown Office officials dealing with the matter?
Can I first of all answer the suggestion that it's disturbing that the government didn't appear at the hearing to deal with reporting restrictions? It is entirely unremarkable where a matter is agreed between parties that a motion should be made and the other party not opposing it shouldn't appear. There's absolutely nothing disturbing in that. It's, as I say, entirely unremarkable in the conduct of civil litigation. So that's the first point. On the second point, I explained in my opening statement that I put in place arrangements right from the outset of this matter so that it would be dealt with by very experienced professional prosecutors on my behalf and without any involvement personally of the law officers. And that's been true also of the contempt of court and other matters that have arisen after the trial. I did that in order to reinforce confidence in the absolute integrity of the administration of justice. Frankly, I wish it were not so, but I recognise that had I taken a different view and law officers had been personally involved, that would have been cast up as evidence of some inappropriate involvement or interference. Now, I don't buy into that for a moment. I don't hope that nobody would, but regrettably, the very fact that, for example, the fact that the material was passed to the Crown Agent is being relied on as evidence of some improper blurring of boundaries, I'm afraid, makes the decision that I took to secure the public confidence in the integrity of this process by putting it entirely in the hands of my most senior professional prosecutor has been vindicated.
Okay, so was it the case then that it was Mr Kenny Donnelly was one of the officials involved along with the Crown Agent, Mr Harvey, and who signed the letter?
Well, Mr Donnelly, you describe him as an official. He is an extremely experienced professional prosecutor. Who holds a,
make no comment about.
Will you let me finish? Will you let me finish, please, Miss Bailey? He's an extremely experienced.
Lord Advocate, if you could hold on. The convener is now back. I'm going to hand over to her. And Lord Advocate, would you please continue what you're saying?
Yes, thank you, Deputy. Thank you, Deputy Convener. Mr. Donnelly is an extremely experienced senior professional prosecutor. As I think the correspondence made clear, the decisions in relation to this matter were taken by Crown Counsel. Crown Counsel are very experienced senior lawyers who hold a commission from me to exercise all the responsibilities, prosecutorial responsibilities of my office, and they do that routinely in the most sensitive cases without reference to the law officers. It's a great strength of our system that I am able to commission a cohort of the most able lawyers in the country to fulfill my functions as prosecutor and to fulfill those functions, if necessary, as they routinely do in sensitive cases without any reference to me. So the decision making in relation to that matter, as with all matters in relation to this case, was in the hands of Crown Counsel. Mr Donnelly, who, as I say, is a very senior Procurator Fiscal, a very experienced prosecutor, he sent the letter. The decision making was in the hands of Crown Counsel.
Okay, can I thank the Lord Advocate for that response, but could I also just point out to him, I have had dealings with Mr Donnelly and I found him to be completely professional, so please don't read into me saying that somebody is an official as a slight. I meant no such slight at all. Now, the Lord Advocate was clearly involved in the judicial review, yet you've taken a decision to recuse yourself from the criminal case, and it could be argued that officials in the Crown Office actually needed your guidance and direction at that critical point. And there was a criticism made of you by the former Attorney General, Lord Falconer, who described it as you were absent without leave. What would you say to that?
I don't accept that characterisation for a moment. As I said a moment ago, it's a great strength of our system of criminal prosecution that I commission Crown Counsel, who, in fact, in terms of my Royal Warrant appoints me and my deputes, which is a Crown Counsel, to exercise the responsibilities of Lord Advocate. And the Royal Warrant goes on to make clear that I am wholly and personally responsible and accountable for their actions. So it's entirely normal and routine in the most sensitive criminal cases for my functions, my decision-making functions, to be exercised on my behalf by Crown Counsel. So that's the first point. I suppose this may come back to the multiple functions of the Lord Advocate. Whether I was or was not involved in the consideration of the judicial review matter, I am a member of the Scottish Government. I am a minister. That is one of the functions that I hold, along with my independent prosecutorial functions. And the that being the case, and given the extreme sensitivity of this matter, and I should say consistent with arrangements, this is a well-worn protocol for the Crown in terms of cases that do raise particular sensitivity. Arrangements were made from the outset to ensure that these matters were dealt with entirely by professional prosecutors, and that was with all respect to the former Attorney General, who comes from a different system, that was a reflection of responsible leadership rather than an abdication of it.
What about then Lord Hope's criticism? And Lord Hope, of course, is an extremely senior law officer. His criticism that he was very surprised at Crown Office intervention in our proceedings.
Yes, can I say I have enormous admiration for Lord Hope, for whom I worked for a year early on in my career. I'm afraid he was not well informed when he made those remarks. I explained in my opening statement the basis for and the reasons for the Crown's approach to Parliament. He, of course, comes from a context, having been in recent years convener of the Crossbench Peers, comes from a context of the UK Parliament, which has particular privileges and has a particular legal position which differs from the position of the Scottish Parliament, and that's the legal position. I make no comment on it one way or the other.
One final question to the Lord Advocate. I'm sure he's delighted with that. On the 26th of August 2018, the Sunday Post newspaper reported that it was in fact you who had ordered referral to the police. Now, I would imagine such a report is totally irregular. Was there an inquiry into this briefing that was given to the papers? And if not, why not?
I'm afraid I simply don't know the answer to that question.
Okay, well, let me put it in more general terms. If it was reported in any newspaper that you had ordered a referral to the police, the only people that could have known that were either within your office or within government. On that basis, is it not hugely irregular that somebody would brief a newspaper of that fact? And given the confidential nature of the complaints, why was that never pursued? Was anything done about that?
Yeah, Ms. Bailey, you're absolutely right that it was highly irregular, and I do remember the article. I'm afraid I can't now remember the response, I hope I may be forgiven given the many things that have happened in the intervening period, the engagement that I have with the whole range of challenges which are facing both the government and the Crown, that I do not keep every detail of these things in my mind. If there's anything I can add, I will, of course, advise the committee of that.
Thank you. I would be grateful for that, Convener, particularly in the context that the Lord Advocate was going to come back to us on when he knew about the complaints and who told him. I have questions for the Crown Agent, but I'm conscious of time, Convener. Can I rattle through them?
Yes, please. Please do.
Thank you very much, Convener. Good morning to Mr Harvey. Can I ask why you tried to hand over the Permanent Secretary's decision report to the police on August the 21st, 2018?
I had received it earlier that morning. I hadn't read it. I explained to the police in the context of a wider conversation about a variety of different aspects that were going to have to be taken forward, including, as we've spoken about already, reaching out to the complainers and setting up appropriate points of contact, etc., that this report had been received. I said specifically that I hadn't read it. I also indicated that now that I had it, it would fall to be considered for disclosure at a later stage in the event that there were criminal proceedings, which at that stage, as I say, it was simply at that point an investigation into potential criminality. And thereafter, once we discussed those various aspects, we turned to consideration about the report. As I said earlier, there were 90 odd years probably of experience in the room and proper conversation about it. And I said, if they were to have it, then we would need to have a collective what it was. And during the course of that discussion, it was the Detective Chief Superintendent who simply said that she didn't want to take it at that time. And that was fine. And there was no great disagreement about that at all. There was no argument about it. Everyone was comfortable, including with the Chief Constable, and we moved on to make other arrangements.
Okay, so you didn't read the report, you didn't know its relevance, and you've confirmed that the police refused to take the report with them. That's helpful.
What they said was that they didn't want to take it at that time, and indeed the Detective Chief Superintendent's evidence at trial is, to be honest, it was my suggestion that I didn't want to take it at that time.
Sure,
And that's accurate.
Fine.
That's accurate.
That's fine. Thank you. What inquiries did you make with the complainers to check that they were content for the report to be handed over?
The report was not handed over. And insofar as the allegations were concerned, the allegations were referred to the police for consideration and to approach the individuals concerned to establish contact with them and to establish their wishes.
But your intention was to hand the report over, and it was only when Detective Chief Superintendent said that she didn't want it that it wasn't handed over. So did you speak to the complainers?
So what my answer was that we had a discussion about what to do with it. And during the course of that discussion, the Detective Chief Superintendent said that she didn't want it at that time. And as part of that discussion, we were discussing the status of it, the fact that I hadn't read it, the fact that they hadn't read it, and the fact that at that stage, regardless of whether anyone had read it, it would fall to be considered for disclosure. And during the course of that conversation...
No, let Mr Harvey finish, please, Ms Bailey.
Okay, no problem.
I said to them that if they were to have it, then we would have to have a collective understanding of what it meant and what it was. And we had then had a conversation about that, and during the course of that conversation, the Detective Chief Superintendent said she didn't want it at that time. At that time. And that's her evidence to trial.
I understand what the Detective Chief Superintendent said, but what I'm trying to establish is that you were prepared to hand it over and no consultation had been undertaken with the complainers in advance of that.
No, what I said was we had a discussion about what to do with it. What was it?
So there was an option to hand it over then?
We were seeking to understand what to do with it and what the status of it was, and we reached the conclusion that it wasn't going to be passed over and it hadn't been read.
Okay. Can I ask why the Crown Agent would be involved in the police inquiry? Because I mean, I understand that the circumstances are quite extraordinary, but is that not quite strange routinely? I don't understand, so I'm looking for your advice and guidance.
Okay. So whilst I'm head of the prosecution service, I remain a prosecutor. And so there are cases in which the Chief Constable and I become involved for a variety of different reasons, usually at a strategic level. He attended this meeting. When I spoke to him on the phone, he was entirely content to come. During the course of the meeting, he was entirely content to be there. And in any discussions that I've had with him since in relation to this matter or anything else, it's been entirely unremarkable that happened in this case. Everyone appreciated the sensitivity and the significance of how this had to be addressed for everyone's interests.
Of course, and I absolutely understand that, and I get why at a strategic level you and the Chief Constable would have a very close working relationship. But can you tell me how many individual cases have you been involved in with the Chief Constable? Because this is an individual case, it's not a strategic consideration.
The Chief Constable and I have on occasion had to discuss individual cases. And
can you give us an idea of how often? It's just so I understand, you know, is this unusual? Does this happen every day, every week? How often?
It would be fair to say that it would only be in the most high profile or sensitive cases that they would be likely to have any such conversation. And as I say, there's no difficulty in this instance with that. It's in fact what one might expect. And if I may add, if it's of assistance, one of the things I would say about this was that from a very early stage, regardless of the outcome here, whether this ended up as an investigation into potential criminality which came to naught, as frankly as often is the case, or whether it ended up being a case that was reported and the Crown took no action, or whether it ended up as a trial. This was a case, and this was a matter that I and the Chief Constable and others involved appreciated was likely to be something regarded of significance and subject to potential scrutiny. And so therefore another element in my consideration as to why I was involved is simply in terms of that scrutiny, which is fair to say one of the things that I did foresee accurately in the circumstances here was that actually that was a matter that it was appropriate for me as head of the service to accept on my shoulders as and when any such scrutiny arose, if it arose. And then, unfortunately, and from my perspective in this instance, that, as I say, is something that I was all too accurate in thinking.
Thank you very much. Oh, can I ask?
Did you hear a voice from the void? Did you? I was just saying, could you come to a close because time is running on you, but a good shout.
I will try very swiftly. It's not Mr Harvey's fault, but other people have been giving long answers, which is great. Can I ask you about the publicity? Because the police advised against any publicity. I'm assuming you raised that with them, recognising how high profile the case was. When they said that you shouldn't take any publicity, did you relay that to the Scottish Government, and who did you relay it to? Because 2 days later, they went to press.
So it was my recollection is that it was raised. My expectation is that anything that was going to be issued would make no reference whatsoever to the referral to the police.
Yeah, but did you communicate that to Leslie Evans, the Permanent Secretary?
At no stage have I spoken to Leslie Evans about this case.
Okay, so the comment by the police about no publicity wasn't conveyed to the Scottish Government, who then went on 2 days later.
No, I didn't say that. I didn't say that. I said I didn't speak to Leslie Evans.
Who did you speak to then?
So I'm trying to recall who it was. It might have been. I'm speculating. I would have to give some thought to it, but I can provide that information. I will check. But the main information was fed back, with which I agreed, and my expectation was that as and when any announcement was to be made, if that announcement was to be made, which would be a matter for government, that the one thing that would not be included was any indication of a referral to the police.
Can I ask, just for my own clarification, is your line manager the Lord Advocate or the Permanent Secretary?
At this stage, I have the arrangements are that there is no direct line management. I'm accountable to the Lord Advocate. As at the point of these events in August 2018, my line manager was Leslie Evans.
Okay, thank you. And my final question, you'll be pleased to hear, Convener,
yes?
is the Parliament, newspapers, Mr Salmon's lawyers, they keep getting letters from officials within the Crown Office threatening all sorts of dire consequences if information is given to this committee. There are a variety of names on these letters, but isn't it the case that actually it's you that's directing them?
I think the Lord Advocate has already answered that. So my involvement directly in this case has been relatively limited, and that the matters that you've identified are matters that are directed by Principal Crown Counsel, who have the full authority of his royal warrant.
So you've not been discussing this, you're not aware of this, this all happens without your knowledge?
Again, that's a different question.
Indeed.
The decision. So you're putting a different question to my answer. So yes, I am aware, but I do not take the decisions in relation to those elements that you've highlighted.
But you would provide advice?
Of course.
That would be your... Okay.
Yes.
I keep asking questions in the hope I get answers. Thank you very much.
I'm trying to give you answers, but the difficulty is you summarise with a different question.
I don't know who I learnt that from. Thank you, Convener.
Thank you. Now, I have 2 questioners left. I'm very anxious that they both get the same courtesy of time as others have had. So can I thank everyone here for their forbearance? I have Stuart McMillan, followed by Maureen Watt. Stuart, if you could stop, we're not hearing you for some reason, which is always a tragedy, in my opinion.
Convener.
That's it.
Okay, thank you, Convener. My questions are aimed to the Lord Advocate, but I think just before I do ask the questions, I've got a couple of things I'd like to. And first of all, I think it's worthwhile just reminding anyone who's watching this that when Ms Bailey was highlighting Lord Faulkner, that Lord Faulkner actually used to be a member of the UK government and the Labour Party a number of years ago. But I think my first question is just regarding the comments from the Lord Advocate about being unremarkable when he spoke about turning up or not turning up. That was following some questions too. So it's regarding the process that has happened in the past. This type of situation, has this been a consistent approach over the course of the devolved Parliament and prior to the devolved Parliament, please?
I'm sorry, I'm not entirely sure what, and it's my fault, I'm not entirely sure what the precise focus of the question is in terms of what's been consistent, but perhaps I can say three things that may, I hope, help to answer the question. The first thing I'd like to say is Lord Fulton is a very distinguished lawyer. He's a former Attorney General. I have great respect for him, but he does come from a different system in terms of the arrangements for both criminal prosecution and the structural arrangements in relation to law officers and so on. So, as I say, what he has to say is, I certainly listen to with interest, but I think it's important to have that perspective, that he comes from a system which is different from ours in relation to these matters. The second point is, if we're talking specifically about parties in a civil case appearing or not appearing at a court hearing, it's not unusual if a matter is not contested or in debate for one party to enrol a motion, for the other side either simply to mark its consent in writing or simply not to oppose it. And I should say the motion will be enrolled in writing in the first place, and the other party has to indicate whether they're opposing it or not in writing. And then if there has to be a hearing, it would be unremarkable for a party that's not opposing or consenting to a motion to take the view that it's not necessary to appear. That's unremarkable. In terms of what's been done consistently or not consistently since devolution, and indeed before, I don't know if the members sort of looking more broadly at the arrangements for in terms of the role of law officers, and the role of law officers has been structurally the same since devolution in terms of the different functions that law officers fulfil. That replicates the structural arrangements that were in place for Scottish law officers before devolution within the United Kingdom government.
The question I want to touch upon is regarding the corporate body decision, and some of this has been discussed earlier on, but I'm really just trying to seek some clarity on the process that would have happened. Earlier on in your comments, Lord Advocate, and I'm paraphrasing you here, that you touched upon, you gave a short explanation as to the process that would have happened. Complainers would have went to the Crown would have went to the Parliament, and the Parliament then acted the way it did by redacting information. So as a consequence of that, would the Crown Office be telling the Parliament's corporate body what it could or could not publish?
To tell a publisher what they can and can't publish, the publisher has to take responsibility for itself. The publisher knows the terms of the court order. They should have access to their own legal advice. The Crown will express concerns. It may express its own view about the interpretation of the court order, but it is always for the publisher itself to take its own view, not least because the only person who can determine whether a publication is a contempt of court is the court itself. And that matter may be raised before the court not only by the Crown but by other parties who have an interest.
Thank you. So with that, the advice that the Crown Office will have given to the corporate body following its publication, would that advice have differed from the advice the Crown Office will have actually given to the Spectator magazine or any other publisher following publication?
As I explained in previous discussions, when the issue of the Spectator publication was being looked at, there was a particular focus on a particular paragraph, and that was addressed. It was frankly only when the matter came back in the light of the publication by the corporate body that certain other matters were identified that gave rise to concern. Now, the issue here is how one puts a particular piece of information, you know, how what one takes from it in light of other information. So it's not, you know, that's the position. That's the position. As I say, once those issues were identified by the Crown, they raised them with the corporate body. The corporate body clearly agreed or accepted that view.
In the case regarding the corporate body, has the Crown been in receipt of any complaints about the Spectator or any other publisher about what they have published?
I'm afraid I'm not in a position to answer that at this moment.
Okay, thank you. In terms of once again, just regarding the corporate body, could it have been the case that if the corporate body had simply decided to redact further than what the Crown Office had actually highlighted, so that decision, just for clarification, that decision would have been taken by the corporate body as compared to by the Crown, is that correct?
Ultimately, any decision, whether it reflects the concerns the Crown has raised or is different, is a decision taken by the publisher themselves.
Okay. Okay, thank you. And just one final question from me, convener. Certainly, Mr Salmon's submission was available from Spectator Online for an extended period of time, and certainly not one Scottish publication decided to publish that particular submission until after it was published by the Scottish Parliament's corporate body. Would that have been because, or potentially have been because, of the advice, the legal advice that the newspapers will have been receiving from their own lawyers, indicating that there was a legal prohibition by the court order regarding that particular submission?
I lost the start of that question.
Okay, sorry. So Mr Salmon's submission was available from it was on the Spectator website. It was on there for an extended period of time, and not one Scottish newspaper decided to actually publish that submission until after the Scottish Parliament's corporate body had actually published it. Now, would that have been because of the legal advice that the newspapers will have been receiving, obviously from their own private legal advice, bearing in mind the legal prohibition that would have been put on it by the court order?
Well, I mean, I can only presume that any publisher will, you know, take their own legal advice and make their own decision in light of that advice.
Okay.
But you know, obviously, one would have to direct the question to them as to what actually happened.
Sure. Thank you very much, Lord Advocate. Thank you, convener.
Thank you. And our last questioner is Maureen Watt.
Thank you, convener. And being last, obviously, a number of my questions have been asked already, so I'll be as brief as possible. First of all, we've heard a lot throughout this inquiry about the term legal professional privilege, or LPP. Can you explain how LPP typically operates for the Scottish Government, please, Lord Advocate?
Yes. Well, every client is entitled to take legal advice and legal professional privilege is the doctrine which entitles any client to keep its legal advice entirely confidential. It's recognised, routinely by the courts. It's such a strong privilege that it can't, unlike other obligations of confidentiality, it can't be overridden ordinarily. So any client's entitled to keep their legal advice wholly confidential. That's true of government as of others. The Ministerial Code recognises that in exceptional circumstances the government may decide to reveal its legal advice, and the Code sets out rules in terms of which the government must address the question of whether it would be appropriate or not to release its legal advice. It's fair to say that release of legal advice is exceptionally rare, and that's true not of all governments in the United Kingdom, of all political complexions, and has been for many years. But on occasion it does happen, and it happens when it's proposed that legal advice should be released. Then the Code sets out the rules in terms of the tests that need to be met before legal advice can be released.
Okay, I mean, in my lifetime, I suppose the legal advice on the Iraq War was asked to be published, and that's what the main one that we think about. But, is it typical for parliaments to pass motions asking for legal advice to be disclosed, in your experience?
Well, I have experience of being in this office for the course of this Parliament, and so far as I'm aware, it's only been in relation to this matter that there have been such motions. In this Parliament, I'm aware that there have been processes in the UK Parliament from time to time, and you're right to mention the Iraq War example. But as I said, it's exceptionally rare for all governments to release their legal advice. On occasion they do so.
Yeah, and there have been a lot more important matters come before this Parliament in this session. Could I move on to the judicial review decision? And it's been said in evidence that the judicial review declared the Scottish Government's policy in relation to harassment, the policy itself, unlawful. Is that your understanding of the decision reached in the judicial review?
No, I don't. What happened in the judicial review, and I think the committee already has quite a lot of evidence about this, is that a concession was made in relation to the application of the policy in this particular case, and it was a concession made on one particular legal ground. Mr Salmon's petition raised a large number of legal objections to the lawfulness of the policy, its application to him, and the way it had been applied in the particular circumstances. None of the other grounds were ever ruled on by the court. So the court didn't rule on the question of whether the policy itself was flawed in any way.
Brought up again in relation to that. And we've also heard a lot about the prospect of junior and senior counsel withdrawing in the judicial review if the government's case was not conceded. Much of what I've heard seems to suggest that this was somehow an additional pressure being brought to bear on the government. However, can you clarify something for me? Isn't it really always the case that a lawyer would withdraw if they thought a client's case was unstateable, a conclusion that, based on the developments internal and external counsel had all reached prior to the concession? And if so, would the possibility of a withdrawal actually change anything?
the member's quite correct that if any professional lawyer reaches the view that an argument that they're being asked to run is unstateable, not properly one which can be put before the court, then the lawyer would have to withdraw from acting. So if one gets to the point that the lawyer's advice is that this is no longer stateable, then the corollary is the lawyer would say, and I can't, I can't present this for you. Every client, of course, is entitled. I mean, this is speaking generally. I'm sorry. I'm just in general. Every client is, of course, then entitled to consider whether another lawyer will present the case. But I mean, that's not an issue that arose here. I suppose it's worth observing that senior and junior counsel, as I think I gave evidence on a previous occasion, there was consistency of representation by the government throughout the judicial review. A point came, as I explained to the committee on a previous session, when the government concluded that it would no longer be on the particular issue, it would no longer be proper to put the argument before the court, and a concession was thereafter made.
But on your recollection, you would think that the government's case in relation to the other aspects of the judicial review were robust, although we will never know because they weren't proved in court.
Well, the government was content that all the arguments, all matters, could be responsibly and properly defended. On the particular issue about the involvement of the investigating officer with contact with the complainers, a point was reached as more information came to light, and I've given evidence about this in the previous session. A point was reached where the government concluded it was no longer proper to seek to defend the case on that ground. No concession was made in relation to any of the other grounds. The government would have been entirely content for a court to adjudicate on those in the sense that it was satisfied that there were arguments that could be properly and responsibly advanced.
Thank you for that. And I'm just thinking about what you've just said in questions to Stuart McMillan. The SPCB redacted 5 paragraphs from Mr Salmon's submissions, and you said you will, as the Crown, draw attention to publishers on what they publish and what they don't. Was each of them redacted on your recommendation, and if so, can you talk us through them?
I can't speak to the specifics of the, what the Crown was inviting the parliamentary corporate body to do, or what the parliamentary corporate body has done, and I certainly can't get into the underlying rationale for any particular redaction. That itself would give rise to potential issues of disclosing things that I can't properly disclose.
Okay, thank you.
If I put it this way, perhaps I don't know if it's helpful. I don't understand there to be any difference between what the corporate body decided to redact and what the issues that the Crown was raising, if that's the question. But that's something I would have to double check and in order to be absolutely sure.
Okay, and we can take it up with the Parliament's lawyers too. Thank you very much.
Okay, thank you. Now, time is running on. I have 3 quick supplementary requests, and please make them quick. Margaret Mitchell, then Alistair Allen, then Stuart McMillan.
Thank you, Convener. Lord Advocate, in terms of the independent scrutiny of the Crown and Procurator Fiscal Service, that's carried out by Her Majesty's Inspection of Prosecution Services. Who appoints the inspector, and when they carry out that report, who do they report to?
I'd have to check precisely who appoints Her Majesty's Inspector. I suspect that she receives a warrant from Her Majesty. The Crown Agent may be able to advise on that. The Inspectorate reports to me, and any report is laid before Parliament.
Advocate, I think you'll find that it's on the recommendation of yourself that the Inspectorate's reports. And can I ask you that you have dual roles when you are unable to carry out your function as head of the Independent Prosecution Service? Who takes over your role? Because of that conflict, who then takes over that role as the independent head of the Prosecution Service?
I'm slightly disappointed I was interrupted when I was seeking to answer the previous question, so I'll finish my answer to that question first. The reason why the Inspector reports to me is because it is for me as Lord Advocate to, and as such as head of the system of criminal prosecution in Scotland, acting independently of any other person, to put in place the appropriate arrangements for the prosecution of crime in Scotland. It's not for anybody else to do that. That rests with the holder of the office of Lord Advocate, and therefore constitutionally it is entirely appropriate that the Inspector reports to me. Any such report is laid before the Scottish Parliament, and I am accountable for my stewardship of the office which I hold to the Scottish Parliament as elsewhere. And so if there are issues that arise from the Inspectorate's report, that's in the public domain, and the Parliament is in a position to hold me to account in that regard. So that's the position in relation to the Inspectorate. On the second question, I remain at all times head of the system of criminal prosecution, and it's for me to put in place appropriate arrangements to discharge that function. As I've already explained to the committee, it is a great strength of our system that I have the power to commission other lawyers to exercise all the functions of my office in terms of the prosecution of crime and the investigation of deaths. Those are advocate deputies, also known as Crown Counsel. These are experienced lawyers who routinely, in the most sensitive and difficult cases, discharge their onerous responsibilities often without reference to the law officers, although there are decisions that from time to time come to law officers, and indeed some decisions come to law officers precisely because in past times commitments have been given to the UK Parliament in particular that certain decisions would only be taken on the instruction of a law officer. So, you know, but across the piece, Crown Counsel exercise the functions of my office in relation to the prosecution of crime and the investigation of deaths on their own responsibility without reference to me or to the Solicitor General for Scotland, and that's a great strength of our system. I, of course, remain accountable for what they do, and that is precisely what I'm doing today in relation to a case where, for the reasons I've explained, the conduct of the case was put entirely in the hands of one of our most experienced, eminent and senior Crown Counsel. He has discharged his responsibilities in the conduct of the particular case, and I am accountable for what he has done. And I may say it is no chore for me to be accountable for the work done by the able professional prosecutors who conduct cases on my behalf. I trust them. I trust them.
Please don't interrupt. Ms Mitchell, please don't interrupt. Could you finish, please, Lord Advocate?
Yes, thank you. I trust them to fulfil the sometimes difficult and onerous responsibilities which fall on them, and they deserve the trust of you and of the public.
Ms Mitchell, do you have a final very short question, please?
My last question is, when you cannot carry out your function as head of the independent Crown and Procurator Fiscal Service, then there is no one person in charge. It may go to a number of people, Crown agents, to fulfil that duty. And I think perhaps that is a weakness in transparency and accountability in the process arising from that conflict, Lord Advocate.
Would you like to respond, Lord Advocate, please?
I would, and I'll try and be brief. I absolutely reject the premise of the question. At no time am I unable to discharge my responsibilities as head of the system of criminal prosecution. As head of the system, I don't have to be involved in every case. Indeed, I couldn't possibly be involved in every case. And sometimes it is my responsibility as head of the system of criminal prosecution to put in place arrangements where I am not involved in a particular case. And while this case is high profile and sensitive and significant, the Crown is dealing every day with high profile, sensitive and significant cases in which I have no personal involvement. That doesn't in any way prevent me from discharging my responsibilities as head of the system, which is to put in place appropriate arrangements for the discharge of the functions of criminal prosecution in Scotland and to account to this Parliament and elsewhere for that function. At no time am I unable to fulfil it.
Thank you. Thank you. Alistair Allen.
Mentioned, Lord Advocate, some of the reasons why anyone, governments included, have a privileged access to legal advice. And you mentioned that there have been rare exceptions where that right to privacy on that has been waived. The Iraq War was mentioned, for instance. Is it still rarer, however, for the right to be waived on that by a government?
I think you missed the end of your question, Mr Allen. Could you repeat the last?
My question was that, without repeating the whole thing, but my question was that while there are examples like the Iraq, the UK or around the UK have released their legal advice, is it rarer for governments to do so in matters of litigation?
Thank you. Lord Advocate.
Well, the legal advice issue, privilege, is important across the whole range of government work. I think, as I explained to the committee on a previous occasion, there are some particular issues that arise in the context of litigation, not least because the nature of litigation is that it involves a challenge to something the government has already done. And therefore, it's unsurprising that matters have to be looked at again. Anyway, I gave some evidence on this before. I've no statistical information about the frequency with which any particular piece of legal advice has been released. All I can say is it is exceptionally unusual.
Thank you. Stuart McMillan.
Thank you, Convener. Just one final brief question. Just it's regarding the Crown officers who will have been communicating with the Parliament. Just to confirm, are they entirely independent of government, and do they make decisions based on an impartial basis?
Yes. The Crown Office operates entirely independently of government. It's imbued in the culture of the organisation and is an article of faith for every professional prosecutor that they exercise their functions impartially, without fear or favour, in accordance with the law and the evidence and the public interest. And they operate entirely independently of government. And so far as my position is concerned, it is my responsibility to exercise my functions as head of that system independently of any other person, and that includes of government. And as I told the Parliament the other day, ministers respect that independence. They do not seek to influence me in the exercise of my independent responsibilities as head of the system of prosecution. If any minister ever tried to do so, they would get short shrift from me, they would get short shrift from the Solicitor General for Scotland, they would get short shrift from the Crown Agent, and no professional prosecutor in the system for which I am responsible would ever entertain any improper or inappropriate attempt to influence their impartial and independent decision making.
Thank you.
Thank you. I have an honestly very quick question, please, Lord Advocate, just before we close. In response to Maureen Watt, you explained the determination of the judicial review and explained about the unlawful aspect in relation to application and policy. Now, I think quite a lot in Mr Salmon's evidence, the term unlawful was used. However, I have seen the term illegal used when public generally, and I think even in the press, are discussing this policy and the outcome of the judicial review. I wonder if you could very quickly just explain for everyone the difference, please, between unlawful and illegal.
Yeah, there are two different questions that when one's talking about whether something's illegal or unlawful. In sort of common parlance, if one talks about something being illegal, one probably is thinking about something that is a breach of the criminal law that simply is prohibited. In the context of the judicial review or cases of that sort, these are civil law questions. The question is whether or not, in that case, whether a particular decision was made in accordance with the legal standards that govern decision-making by government. And if a decision is made that doesn't satisfy the legal standards that apply to decision-making by government, then that decision is unlawful and it is quite properly set aside and has no legal effect. That doesn't mean that it's illegal in the sense of being a breach of the criminal law. That's quite a different question. So I think it's perhaps quite important to be clear when one's talking about unlawfulness or what the nature of the unlawfulness is that one is thinking about.
Okay, thank you. Thank you, everyone. That brings us to the end of our evidence session today. I want to particularly thank the Lord Advocate and the Crown Agent for their evidence. You've both given us much of your time and it is appreciated. The committee will now suspend for 15 minutes and then we will move into private.